Good afternoon, everybody. I hope everybody is keeping safe. And today we will be discussing the concept of maintenance, which has been given under CrPC. Although the word Criminal Procedure Code suggests that it is a procedural enactment, but it also confers certain substantial rights. And one of such right is the right which is conferred as regards the maintenance of wives, children, and old age parents, which has been given under Section 125 of CrPC. According to the observation of the Apex Court in the case of Shana versus BG Shivanjappa 2005 4 SCC 468, wherein the Apex Court held that Section 125 to 128 of CrPC are to be treated as a measure of social justice and therefore need to be construed liberally. This concept of maintenance, which has been given under Section 125, is, as pointed out by the Apex Court in the case of Shana versus BG Shivanjappa, it is a measure for social justice, and it is specially enacted to protect the women and children and also the infirm and poor parents. And it falls within the constitutional sweep of Article 15, Subclause 3, which is also reinforced by Article 39 of the Indian Constitution. This section, as regards maintenance, it gives effect to the natural and fundamental duty of a man to maintain his wife, children, and old age parents. Most of you must be aware about the landmark case as regards Section 125, which is Muhammad Ahmad Khan versus Shah Banu Begum, 1992, Criminal LJ 899 MP, wherein the Apex Court held that Section 125 is applicable to all, irrespective of their religion. It was therefore held that it will also be applicable to Muslim women. But, thereafter there was a lot of revolt which was done by some of the Muslim leaders in our country. Therefore, the Parliament passed the Muslim Women's Protection of Rights on Divorce Act of 1986, which provides other remedies for Muslim women and allows them to use the remedy under Section 125 of CrPC only if the husband consents to it. And in the absence of a declaration by the husband that he would prefer to be governed by Section 125 to 128, he will be governed under Section 5 of this Act of 1986. And under this Act, the divorced Muslim wife was not granted maintenance. This Act of 1986 took one retrograde step in the form that it said that husband's liability to provide for maintenance is only for the iddat period. The judicial invocation, which was passed in the Shah Banu case, has been killed by this Act of 1986. The position of law reversed again in the case of Daniel Latif versus Union of India, 2001, 7 SCC 740. And it was held that Muslim husband is liable to make reasonable and fair provision for the future of divorced wife, which obviously includes her maintenance as well. But such a reasonable and fair provision extending beyond the iddat period must be made by husband within the iddat period as per Section 3, subsection 1, subsection A of the Act of 1986, as per which a reasonable and fair provision is to be made and paid to her within the iddat period by her former husband. Now, this concept of maintenance has also been provided under Section 24 and 25 of the Hindu Marriage Act. As per Section 24 of the Hindu Marriage Act, it states that it provides rather that either party to the proceedings can ask for his or her maintenance pendent lit. Pendent lit means during the proceeding and expenses of the legal proceedings from the respondent. Similarly, the provision of maintenance has also been provided under Section 18, Section 19 and Section 20 of the Hindu Adoption and Maintenance Act of 1956. Because most of the times the questions are asked in the competitive exams, and also sometimes in college they ask that apart from CrPC, under which other law the concept of maintenance has been given. So you'll have to go to section 24 and 25 of the Hindu Marriage Act 1955, section 18, section 19 and section 20 of the Hindu Adoption and Maintenance Act of 1956. Now, section 18 of the Adoption Act, it casts an obligation upon the husband to maintain his wife during her lifetime. Section 19, to be specific, subsection 1, is to the effect that a Hindu widow shall be entitled for maintenance after the death of her husband from her father-in-law, provided she is unable to maintain herself. Section 19, subsection 2, says that the father-in-law shall not be under an obligation to maintain the widowed daughter-in-law if he has no means from any compulsory property in his possession, out of which the daughter-in-law has not obtained any share. Similarly, section 20 of the Adoption Act casts an obligation upon a Hindu during his or her lifetime to maintain his or her legitimate or illegitimate minor children and his or her aged or infirm parents. Now, the term wife, which has been used under the explanation B of section 125 subsection 1, what does wife means? It includes even a divorced wife so long as she has not remarried. Wife means only a legal wedded wife, but the personal laws applicable to the parties would govern legality of the marriage. If the fact of the legally valid marriage is disputed, the applicant will have to prove the marriage. For example, it is for the husband to prove that his first marriage was valid to sustain his plea that his second marriage was invalid. However, the standard of proof is not so high as in the case of Divorce Act or under section 494, 495, 497 and 498 of IPC. Similarly, the term child, most of the times in exams it is asked that what exactly the word child means under section 125. So under section 125, a child can claim maintenance not only from the father but from the mother as well, because the word person over there includes male as well as female as per the Gender Clauses Act of 1897. A minor married girl can claim maintenance either from her husband or father or both. Now, if the husband of a minor married female child is not in possession of sufficient means, the father of such female child will be required to make the allowance for the maintenance. However, a married daughter is not entitled to maintenance from her father if she has attained the age of majority, because she would then come under the category of wife and would be entitled to maintenance from her husband. The term father and mother under section 125. The term, a father or mother who are unable to maintain themselves are entitled to claim maintenance from his or her son. The question arises about the fate of the persons who have sole daughter. Section 125 subsection 1 does not specifically speak about the liability of the daughter to provide the maintenance, but in the case of Vijay Manohar Arbat versus Kashirao Rajaram Savai, 1987, 2 SCC 278, it has been held by the Supreme Court that daughter, whether married or unmarried, is under an obligation to maintain her parents. Now, what the question that can be put forward in examination is also, what is the difference between dower and maintenance? Both these concepts are two distinct concepts. Dower originates at the very inception of the marriage, and it is a mark of respect for the wife. It kind of provides a security against the divorce. Whereas maintenance upon divorce is symbolic of a break of the conjugal relations between a husband and a wife. Now, this question was, asked infrequently. We've gone through some of the papers where there was this question that whether the minors are entitled to claim maintenance from their father, even if they are in custody of the mother who is living separately. The answer to this question is that, the father is bound to maintain his child, even if the child is living with the mother, being a natural guardian, and it is not open to him to impose a condition that the child must live with him, because a natural guardian is considered to be the mother. In a case where the father is a natural guardian, but the child is in the custody of the mother, father's obligation to maintain the child subsists, and he cannot impose a condition requiring the child to come and live with him. In such a case, the father must obtain the custody of the child from the proper court. But till the time the custody is obtained, the child must be maintained wherever it is. Now, Section 127 talks about the alteration in allowance. The provisions of Section 125 have been enacted to protect the weaker of the two parties. Therefore, if an order of maintenance has been made by a court, it will operate until it is modified or cancelled by a superior court, or it is varied as per terms of Section 127 or Section 125 subsection 4 or 5 of the code. Section 127 empowers the magistrate to decrease or increase the amount of maintenance or interim maintenance. Now, the legislature under Section 125 has left it to the discretion of the magistrate to award maintenance either from the date of the application or from the date of the order. No such discretion has been left to him while dealing with an application under Section 127 subsection 1. The order which is made under Section 127 subsection 1 shall be effective from the date of such order and not from the date of application of alteration. In case of enhancement of the maintenance, the order for the enhancement of maintenance can be passed by the court which awarded the maintenance and not the execution court. Now, the word decision in the subsection means the determination of a question or controversy on which the maintenance was sought or granted. Now, if a wife claiming maintenance without sufficient cause or reason refuses to live with the husband, or if the court has passed a decree of restitution of conjugal rights in favor of the husband and the wife, without reasonable excuse, has withdrawn from the society of the husband, then that decree of the court makes out a ground under Section 127 subsection 2 for cancellation of the order of maintenance. If a woman claiming maintenance after getting the divorce from a husband remarries another person, she will not be entitled to claim the maintenance. If a woman after getting divorced from her husband has voluntarily surrendered her rights to maintenance or interim maintenance, the magistrate, if satisfied about these events, can cancel the order from the date of that order. Similarly, Section 128 talks about the enforcement of order of maintenance. It states, the copy of the order of the maintenance shall be given free of cost to the person in whose favor the order of maintenance has been passed by the magistrate, and in case the wife is a minor, the copy of the order shall be given to the guardian of that minor wife. This was all about the concept of maintenance. If still there are any queries, please let us know. We will answer them. Now we will be dealing with the topic of maintenance of public order and tranquility, which has been given from Section 129 to Section 148. Now, Section 129 of CrPC talks about the dispersal of assembly by use of a civil force. The magistrate or officer in charge of a police station is empowered to take action or order for dispersal of an unlawful assembly. There may arise a situation when the officer in charge of a police station is not available or could not be reached out. In such a situation, an officer not below the rank of a sub-inspector can also take action against such assembly for preventing any disturbance of public peace or destruction of public property by such unlawful assembly. Now, force can be used against such assembly only under 4 conditions. Firstly, if there is an unlawful assembly with the object of committing violence, or an assembly of 5 or more persons is likely to cause disturbance of the public peace. Secondly, if such assembly is ordered to be dispensed. Thirdly, if in spite of such order, such assembly does not dispense. And lastly, the code empowers the magistrate or an officer in charge of a police station to order for dispersal of an unlawful assembly. But they can also order for dispersal of other assemblies which are potentially unlawful assemblies. Now, this term unlawful assembly will mean the one which has been defined under Section 141 of IPC. Section 131 talks about the use of armed forces to disperse the assembly. It states that if there is a threat to public security by any unlawful assembly or an assembly which is not unlawful but it causes imminent danger to public security and a magistrate cannot be contacted at that specific time, any commissioned or gazetted officer of the armed forces may act with the head of armed forces in dispersing the assembly. Now, the concept of public nuisance. Section 133 talks about the conditional order for the removal of nuisance. The purpose of Section 133 is to prevent public nuisance. Now, if a magistrate fails to take immediate recourse to Section 133, irreparable damage would be done to the public. It is intended to remove the public nuisance and can be invoked in urgent cases because the nuisance can sometimes be fraught with potential danger requiring the immediate action. Herein, the magistrate referred to as the executive magistrate. An executive magistrate, upon receiving a police report or other information in respect of public nuisance, can exercise the powers under Section 133 in 6 circumstances which are enumerated in subsection 1 of Section 133. Similarly, Section 133 talks about the service or notification for order. It states that the order shall be served to the person against whom it is made in the manner provided for the service of summons. Like we discussed how the summons are served. Similarly, the order as regards this Section 134 shall be served in the same manner. If an order which is made under Section 134, subsection 1 remains unserved, the same shall be notified by the proclamation by publishing it in such manner as is prescribed by the state government. Section 135 talks about the person to whom the order is addressed to obey or show cause. Under Section 135, 2 alternatives are given to a person. Either he can come to perform the acts directed by such order within the prescribed time, or he can show cause for his non-compliance with the order. Similarly, Section 136 talks about consequences of failing to do so. If a person does not perform such act which he is required to perform as per the order, or he does not show cause, he shall be liable to the penalty which is prescribed under Section 188 of IPC. Now, Section 139, it talks about the power of magistrate to direct investigation and examination of an expert. The magistrate under Section 139 can direct a local investigation to be made by the person as he thinks fit for the purpose of an inquiry. A local investigation does not merely mean one's own observation of the things, but even ascertainment of facts by recording the statement of certain witnesses, this was held in the case of Amar Singh versus State of UP 1980. Section 140 talks about the power of magistrate to furnish written instruction. The magistrate shall give written instructions to the persons who are directed to carry out the local investigation. The order shall direct as to who will bear the expenses of the investigation, whether the whole or any part of such necessary expenses. There may arise a situation in which the magistrate may summon and examine an expert under Section 139 for the purpose of investigation. Therefore, he can also order or direct as to who will bear the expenses of calling an expert for his opinion. Section 141 talks about procedure on order being made absolute and consequences of disobedience. The magistrate has to inform the person against whom an absolute order has been passed under Section 136 and the acts that he is required to perform by such order within the prescribed time. Now, if the person against whom such an absolute order has been passed disobeys it, then proceedings under Section 188 of IPC will be initiated against him. So now, the last part talks about the urgent cases of nuisance and apprehended danger. Section 144, power to issue order in urgent cases of nuisance and apprehended danger. Section 144 is well known and it is used frequently. It authorizes the senior magistrate to issue orders in urgent cases of nuisance or apprehended danger. The order becomes absolute the moment they are issued. Such orders issued under Section 144 must be in writing, clearly stating the material facts on the basis of which such absolute orders were passed. An order under Section 144 is essentially an executive order passed in performance of an executive function where no list as to any rights between rival parties is adjudicated merely. An order preserving peace is made and such it will be amenable to writ jurisdiction, either under Article 32 or Article 226 of the Constitution, if it violates the fundamental rights. Which the order which is issued under Section 144 violates any of the fundamental rights, then writ can be passed, as it was held in the case of Ghulam Abbas versus State of UP, 1981, 4 SCC 521. Most often than not, the questions are asked, what is the difference between Section 134 and 144? The answer is that under Section 144, the order becomes absolute the moment they are issued. On the other hand, the orders which are passed under Section 134 are always preliminary orders. Now, what is the duration of the order? Now, Section 144, order remains in force for a period of 2 months from the date of the order. If it is issued on 1st January, for instance, then it will remain in order for 2 months. But the state government can extend the duration of the order made under Section 144 if it considers it necessary in order to prevent the danger to human life and to preserve health and safety. The extension of the magistrate's order beyond the period of 2 months is to be done through a notification only. The Supreme Court in the landmark case of Acharya Jagdishwaranand versus Commissioner of Police, Calcutta, 1983, 4 SCC 522, has stressed that an order under Section 144 is intended to meet an emergency and the same cannot be permanent in character. Repetitive order extended duration is not contemplated in Section 144, and if the same are issued, then it would clear tantamount to abuse of power. Now we will be dealing with the remaining provisions, which talks about the disputes as to immovable property. Section 145 talks about procedure where dispute concerning land or water is likely to cause breach of peace. Now, what exactly? More often than not, a question may be asked: what is the objective of Section 145? The objective is, Section 145 contains certain important provisions regarding cases of disputes concerning land or water which are likely to cause a breach of peace. It provides that whenever an executive magistrate is satisfied, either from a report of a police officer or any other information, that a dispute is likely to arise to cause a breach of peace which exists concerning any land or water or the boundaries thereof within his local jurisdiction, he must make an order in writing stating the grounds of his being satisfied and requiring the parties concerned to attend the court in person or by a pleader. Now, the preventive action under Section 145 can be taken if, firstly, there is a dispute relating to land or other objects mentioned in subsection 1. The dispute is likely to cause breach of peace. Now, the order under Section 145 shall be in writing, and it must be clear, precise and full as to give complete idea of the case to the parties concerned, and it is a basic order, and failure to draw it up would vitiate subsequent proceedings, as held in the case of Mathura Lal versus Jawahar Lal, 1979 Supreme Court. Now, the words forcibly and wrongfully cannot be given a restricted meaning, and therefore disposition accompanied by the use of criminal force as defined in IPC. The use of misrepresentation and improper threats would make the disposition forcible and wrongful, as held in the case of Tarulata Devi versus Nikhil Bandhu Mishra, 1982 Supreme Court. Section 146 talks about the power to attach property. After a preliminary order has been made under Section 145 subsection 1, 3 contingencies have been contemplated in which an order of attachment under this section can be passed. Firstly, if the magistrate considers the case to be one of emergency, if it decides that none of the parties were in the possession of such property, and if he is unable to satisfy himself as to which of the parties were in possession. For considerable time, the High Courts, while interpreting Section 145 and 146, were divided over the issue as to whether the magistrate's jurisdiction under Section 145 comes to an end on attachment of the disputed property under Section 146, subsection 1 on the ground of emergency. Now, this question was answered by the Supreme Court in Mathura Lal versus Bhawar Lal, 1980 Criminal LJ. That Section 146 is not to be torn out of its setting and read independently of Section 145. Section 145 and 146 together constitute a scheme and section 146 is to be read only in the context of section 145. The court further held that the magistrate's jurisdiction does not come to an end as soon as an attachment is made on the grounds of emergency as given under 146 subsection 1, except for the reason that there is no dispute likely to cause a breach of peace, and as provided by section 145 subsection 5. A proceeding initiated by a preliminary order under section 145 subsection 1 must run its full course. Now, section 148, talks about local inquiry, which says that whenever a local inquiry is necessary for the purpose of section 145, 146, or 147, the district magistrate or the subdivisional magistrate may depute any subordinate magistrate to make an inquiry, furnish him with the necessary written instruction for his guidance, and declare by whom the whole or any part of the necessary expenses are to be paid. Now, this was all about your the concepts of the maintenance, and also the topic of maintenance of public order and tranquility. If there is any query as regards it, as regards any word used in the Bear Act or any other queries that you may have, please drop us a mail and we will answer it.